Good morning. My name is Julie Whitman Klein, and I would like to welcome you to the 2019 Trinity Health Freedom Expo. Okay. The expos are brought to you by Trinity School of Natural Health, and this expo is our 26th event. I just want to thank you for coming. As an attendee over the next 2 days, you will have access to natural and alternative healthcare information and products. Trinity Health Freedom Expo is about meeting the people who are making the discoveries and having a hands-on experience with new and exciting products. This is a place where you can learn how to achieve a naturally vibrant and healthy life. I encourage you to take your wellness in your own hands. Make decisions that are best for you. Several of our speakers and exhibitors will empower you, enlighten you, and educate you. We will learn just how important it is to fight for our health freedom. Our slogan for the Health Freedom Expo, since the very first expo that was held in 2005, is protecting your freedom and having a right to know and a right to choose. So I'd like to tell you about our first speaker that we have here this morning. Jonathan Emord is an attorney who practices constitutional and administrative law before the federal courts and agencies. He is AV rated by the Martindale-Hubbell Law Rating Organization, which is highest in legal ability and ethics. A federal litigator, Emord has defeated the Food and Drug Administration a remarkable 8 times in federal court, more than any other attorney in American history. He was lead counsel in the landmark case of Pearson versus Shayla decision, holding the FDA censorship of nutrient disease claims unconstitutional under the First Amendment. He is also the author of 5 critically acclaimed books on law and government, including Freedom Technology and the First Amendment, The Rise of Tyranny, and Restore the Republic. He is the guest lecturer at Georgetown University Medical School and Georgetown University Law Center. He is also the American Justice columnist for USA Today magazine. So please welcome someone I call my friend, Mr. Jonathan Emord.
Me now? Okay. Thank you so much, Julie. This is a wonderful opportunity for all of us, and without the Trinity Health Freedom Expo, there wouldn't be this tremendous chance to learn so much in such a few days. Well, today you're going to have the privilege of actually getting a PhD in legal history within 30 minutes. And if I'm wrong, you can come up here and chase me out. I've got an exit door that I put here from my experience and study of the Constitution, I have concluded that the administrative state, which accounts for the overwhelming majority of all federal law created and enforced by the federal government, violates the Constitution and should be eliminated. Indeed, administrative agencies do not adhere to the Constitution's limit on power, violate the Constitution's separation of powers doctrine by employing combined legislative, executive, and judicial powers in extra-legal ways that prevent the accused from ever receiving a fair and impartial trial on the merits, operate what are in fact agency kangaroo courts, and generally serve as federal wrecking balls that destroy freedom and free enterprise for partisan and corrupt purposes. Columbia University law professor Philip Hamburger explains in his book, Is Administrative Law Lawful? There is a jarring disconnect between what is taught and celebrated in constitutional law and what is accepted in administrative law. The one offers a vision of divided power exercised through and under law. The other presents the reality of consolidated power exercised outside and above the law. Okay, so the liberty established, he goes on to say, the liberty established by the Constitution is a liberty under law, not a liberty under administrative fiat. It is a complete freedom to do whatever is not forbidden by law, and any attempt to impose extra legal constraints is unconstitutional. Although administrative law is a mode of power unrecognized by the Constitution, it has become the government's primary mode of controlling Americans, and it increasingly imposes profound restrictions on their liberty. It therefore is time to reconsider the lawfulness of administrative law. That's Professor Hamburger from Columbia. Let's recall the foundational principles that define the meaning and scope of our government under the Constitution. The political upheavals of the 17th century in England, Scotland, and Ireland, the English Civil War, the beheading of Charles I, the Glorious Revolution of 1688, and the deposing of King James II and VI, gave birth to a political party in England that held sway with colonists who agitated for revolution, including all who ultimately drafted and adopted the Declaration of Independence and the Constitution of the United States. That political party, the Radical Whigs, was the opposition political movement to the Hanoverian kings, the kings of England, the Georges. The Radical Whigs favored the political theories of John Locke, author of 2 treatises of government. In particular, the Radical Whigs agreed with Locke's theory of natural rights, also known as pre-political rights, and rejected the divine right of kings, that only the king was possessed of rights, Sir Robert Filmer's theory in Patriarcha. The Radical Whigs identified 2 major threats to individual rights. One was unlimited government, which inevitably led to corruption and abuse of power, and the other was government void of checks and balances, which inevitably led to encroachments whereby tyranny would replace liberty, as evidenced by the efforts of Charles I and James II and VI to deprive Parliament of the power to represent the people in making laws. The Radical Whigs favored what was called a mixed constitution, believing pure democracy as tyrannical as absolute monarchy. By mixed constitution, they meant a state composed of democracy in the legislature, aristocracy in the courts, and monarchy in the executive, which powers, if divided, limited, and checked, would prevent evils in the form of anarchy, oligarchy, and tyranny. The Radical Whigs of the 18th century, particularly Thomas Gordon and John Trenchard, the authors of Cato's Letters, who wrote 144 letters on liberty, published serially in the London Journal from 1720 to 1723, praised natural rights, a mixed constitution and a republican form of government, and the separation of powers as bulwarks in defense of liberty. They railed against despotism in the form of pure democracy, absolute monarchy, and governments not based on popular consent. The Radical Whig view formed the intellectual foundation of the American Revolution, the Declaration of Independence, and the Constitution. We can see the core Radical Whig philosophy in the Declaration of Independence. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. The Constitution of the United States is a first in world history. It was uniquely a written constitution, making the supreme law fixed and certain. It is the first premised on popular sovereignty, the consent of the governed, and designed to protect the rights of the governed. It is the first to grant the government only limited and defined powers. As James Madison put it, our government is limited by the authority of a paramount constitution. Thomas Jefferson aptly defined the liberty designedly protected by our Constitution when he wrote to Isaac Tiffany on April 4th, 1819, "A liberty then, I would say, that in the whole plenitude of its extent, it is unobstructed action according to our will. But rightful liberty is unobstructed action according to our will, within the limits drawn around us by the equal rights of others. I do not add within the limits of the law, because law is often but the tyrant's will, and always so when it violates the rights of an individual." Among the key constitutional principles limiting the power of the federal government were the following: the separation of powers. As Madison put it in Federalist Number 47, the accumulation of all powers, legislative, executive, and judicial, in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. An independent judiciary, where the courts serve as guardians of the Constitution. In Federalist Number 10, James Madison wrote, "No man is allowed to be a judge in his own cause, because his interest would certainly bias his judgment, and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judges and parties at the same time." Alexander Hamilton added in Federalist Number 78 that it is the duty of the federal judiciary to declare all acts contrary to the manifest tenor of the Constitution void, and without this, all reservations of particular rights or privileges would amount to nothing. The judicial vesting clause of Article 3, where only the federal courts may determine the legality of acts by the federal government. Article 3, Section 1 reads, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish." The guarantee of a jury trial in civil and criminal matters, where actions of the government to deprive an American of property or liberty are not permitted unless pursuant to the due process and a trial by jury. The Seventh Amendment guarantees the right to a jury trial in all civil cases brought by the United States, in all suits at common law where the value in controversy shall exceed $20. The right of jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined by a court of the United States. Article 3, Section 2 provides that criminal trials must be by jury, in the state where the alleged crime was committed. Article 3, Section 2 reads, "The trial of all crimes shall be by jury, and such trial shall be held in the state where the said crimes have been committed." The legislative vesting clause of Article 1, where only the Congress of the United States may make laws to govern the people who elected them. Under the Constitution, the entire legislative power of the United States, the entire power, the power to make law, is vested unambiguously in Congress alone, not in any sub-department or agency. Article 1, Section 1 reads, "All legislative powers herein granted shall be vested in a Congress of the United States." An essential theory of our government is that law is legitimate if adopted by the elected representatives of the people. In the 1790s, Samuel Slater introduced methods of textile manufacturing to America and effectively initiated the Industrial Revolution. A once exclusive agrarian economy became an industrial one, with factories and steam engines and steamships and railroads. Principally, the rise of the railroads in the 1880s led to calls for regulation. At first, states created agencies to limit railroad rates, which were thought too expensive by agricultural interests. But in 1886, the Supreme Court handed down its Wabash decision, Wabash-St. Louis and Pacific Railway Company versus Illinois, wherein a majority of the court ruled that direct burdens on commerce were not permitted by the export tax clause of the Constitution, Article 1, Section 9. However, indirect burdens were permitted under the Commerce Clause, Article 1, Section 8, Clause 3. That effectively limited state railroad regulation and led Congress to pass federal railroad regulation via the Interstate Commerce Act in 1887 during the administration of Grover Cleveland. A little earlier, in 1848, a German political philosopher and economist named Karl Marx wrote a book called The Communist Manifesto. Marx's curious new philosophy called for government to take over all means of production to liberate the proletariat or working class from an alleged capitalist slave labor and to redistribute the wealth of the middle and upper classes to the poor in a forced effort to achieve income equality. That is, in his words, from each according to his ability to each according to his need. That's a slogan proclaimed in his 1875 critique of the Gotha program. Academics in America were intrigued by Marx. They asked whether Marxism could be exported to America to counterbalance capitalist industrialization, which they found unsettling. I cannot overemphasize the extent to which academic sympathy with state-driven solutions affected public policy between the mid-1880s and the mid-1930s. Academics at Harvard, Yale, Columbia, Johns Hopkins, the University of Michigan, and the University of Pennsylvania advocated abandonment of constitutional limits on federal power in favor of efficient and omnipresent regulation of the market through a new federal administrative state. Lauding the German administrative state, the Reichsstaat, these professors, as early as the first decade of the 20th century, rejected the Lockean social compact theory that undergirds the Constitution in favor of government that would closely supervise, investigate, and direct the economy through the subjective and ever mutable rule of government administrators. In other words, they preferred the rule of men over the rule of law, precisely the opposite of the founding generation. Law professors like Ernst Freund at the University of Chicago, Scott Nearing at the University of Pennsylvania, Frank Goodenow, Carl Llewellyn, Adolph Burrell Jr., and Rexford Guy Tugwell at Columbia University, Felix Frankfurter, James Landis, and Calvert Magruder at Harvard, and Jerome Frank and Abe Fortas at Yale were all vocal proponents of an extra-constitutional administrative state without resort to the amendment process required under Article 5 of the Constitution. They call for agencies outside the constitutional branches, replete with combined legislative, executive, and judicial powers, what James Madison had earlier condemned as tyranny, to serve as a counterweight to private enterprise, limiting liberty and property rights to serve an amorphous interest of the community or public interest. Those phrases were in fact a cover for supplanting the rule of law with implementation of the academics' own plans for restructuring private enterprise and social relations in America. An army of progressive lawyers from these schools descended on Washington in the first 3 decades of the 20th century to promote and staff agencies favored principally by the administrations of Theodore Roosevelt, Woodrow Wilson, and Franklin Delano Roosevelt. They generated central plan after central plan in a feverish attempt to channel capitalism into pursuits they deemed in the public interest. In 1917, the world witnessed another curiosity that many American academics admired, the Bolshevik Revolution in Russia. Scholarly publications hummed with tributes, fawning over the Russian workers' paradise, where government controls were said to arrest capitalist abuses of the working class. The very antithesis of the Constitution of 1787 came to be viewed favorably by leading academics, some of whom became influential in creating the administrative state. Economist Rexford Guy Tugwell, who helped design Roosevelt's New Deal programs and created the Resettlement Administration, admired Soviet central planning, concluding that it produced goods in greater quantities and spread prosperity over wide areas of the population. A student impressed by his professor, Scott Nearing, a self-avowed socialist at the University of Pennsylvania, Tugwell visited the Soviet Union in the summer of 1927 and went on a propaganda tour for Westerners, which avoided evidence of widespread famine and murderous purges. A tour designed by Soviet Premier Joseph Stalin. Tugwell marveled in naive wonderment at the success of communism. Sounding like Karl Marx, Tugwell thereafter in 1933 called for tax increases in the middle of the Great Depression to bring about redistribution of wealth. He demanded government, quote, take incomes from where they are and place them where we need them, unquote, paraphrasing Marx's "from each according to his ability, to each according to his needs." Many of Tugwell's friends who either served in the Roosevelt administration or advised the president were avowed socialists or members of the League for Industrial Democracy, the successor organization to the Intercollegiate Socialist Society. Jim Powell writes in FDR's Folly, among FDR's advisors, Tugwell was the best-known advocate of central planning, and his political fortunes rose and fell with the National Recovery Administration, the New Deal's biggest attempt at central planning, held unconstitutional by the Supreme Court. While some who came into the federal government to expand its role in the economy were advocates of an agrarian society and small business, fearing the social and economic changes of industrialization, others were fully committed socialists who wanted a government takeover of the private sector under the Soviet model, or if not, at least regulatory control of the private sector. Frances Perkins, who Roosevelt chose to be his Secretary of Labor, was a member of the Socialist Party and a stern critic of big business. She oversaw operation of the Civilian Conservation Corps, the Public Works Administration, the Federal Works Agency, and the labor parts of the National Industrial Recovery Act. And she successfully pushed for passage of the Social Security Act. Among the most vocal in promoting agency regulation were Professors Felix Frankfurter and attorneys Louis Brandeis, whose industrial philosophy was that bigness is always badness, unquote, according to Tugwell, and George Rubley. Brandeis helped draft antitrust laws and favored federal regulation to dismantle virtually all big business. Rubley drafted progressive-era legislation in the Theodore Roosevelt administration, writing the Federal Trade Commission Act, for example, and he served as one of the FTC's first commissioners. The essential argument for the administrative state was that the power-limiting doctrines of the Constitution, such as those that required a separation of powers, that only Congress make the laws, that only the federal courts exercise the judicial power, and that required a trial by jury when government deprived a person of liberty or property, were anachronistic in the industrial age and should be circumvented by the administrative agencies wielding unlimited power. They argued that Congress and the federal courts were too slow to address rapidly evolving economic issues, were incapable of addressing effectively national economic and social emergencies, and lacked expertise necessary to comprehend complex areas of science in the industrial age. They chose not to amend the Constitution, as the Constitution requires, to permit delegation of combined legislative, executive, and judicial powers to unelected heads of bureaucratic agencies. They just did it, ignoring Article 5's requirements. In this respect, they were disdainful of the Constitution, often referring to it as archaic and impractical. Brandeis argued for what he called a living Constitution, one that was mutable and could be reinterpreted to abandon the Constitution's limits on power. No clear and precise legal explanation has ever been given concerning how the administrative state's extra-constitutional powers square with the Constitution's requirements. Despite that intellectual void, the administrative state has grown, largely in response to actual or concocted emergencies. In 1929, following a booming economic period, the so-called Roaring Twenties, the stock market crashed and America entered the Great Depression. In response, Franklin Roosevelt assembled his so-called brain trust to devise and implement New Deal programs. Although regulation was promised as the way to lift the nation out of the Depression, it had the opposite effect, lengthening and worsening the Depression, even causing a second economic collapse in 1938. Although ineffectual in ending the Depression, the New Deal fundamentally altered the relationship between the individual and the federal government, solidly establishing the administrative state as an extra-constitutional fourth branch that touches the lives of each of us. The New Deal ushered in 15 new federal regulatory agencies in President Roosevelt's first 100 days. The emphasis was on reform rather than revitalization of the economy. Between 1935 and 1936, 5 of the 9 Supreme Court justices, Pierce Butler, James McReynolds, George Sutherland, Willis Van Devander, and Owen Roberts, held 6 Roosevelt New Deal statutes unconstitutional, either as a violation of the Commerce Clause or of the non-delegation doctrine, whereby the court deemed federal agencies created by those statutes unconstitutional. In response, Roosevelt proposed legislation to change the composition of the court from 9 justices to 15, enabling him to appoint 6 new justices who favored his New Deal. Although the court packing plan never became law, it effectively won the day as some justices switched their votes, what newspapers of the time called the switch in time that saved 9, holding constitutional the very assumptions of power previously held unconstitutional. Other justices retired from the bench, enabling Roosevelt to put progressive justices on the court who would uphold his New Deal programs. Since the 1930s, no delegation of legislative, executive, and judicial power by Congress to federal agencies has been declared unconstitutional. Not one. Over the years, in Democratic and Republican administrations alike, ever greater numbers of federal agencies have come to be, and the old ones have grown ever larger in size, scope, and power. Beginning with the Supreme Court's 1932 decision in Caldwell versus Benson, and continuing thereafter until the Supreme Court's 1984 decision in Chevron USA versus Natural Defense Council, the High Court has broadly deferred to agency fact-finding and legal determinations, electing not to perform substantive independent judicial review of agency actions. The federal courts have thus made the extra-constitutional agency's decisions, with rare exception, the supreme law of the land. The consequence of this abnegation of the court's duty to say what the law is, Marbury versus Madison, has been the firm establishment of a government outside the Constitution, an extra-constitutional fourth branch comprised of over 100 administrative agencies that rule with near absolute power. Defendants before the agencies are afforded very few of the protections in Article III courts of law and are routinely denied an independent judge, denied charges that remain invariable during adjudication, denied fair and full discovery against the government and private accusers, denied any viable way to restrict unduly burdensome government discovery and investigations, denied a jury trial, and denied an opportunity to confront their accusers. I fought administrative agency deprivation of property and liberty rights for 35 years. I have witnessed numerous instances of agency corruption and abuse, industry capture, protectionism, bias, arbitrary decision-making, attempted bribery, suppression of evidence, and censorship. 4 examples will illustrate: the FDA, corruption, and industry capture. In the mid-1990s, Purdue Pharma, makers of OxyContin, suddenly changed its marketing strategy for opioids. The wealth it generated from its new marketing soon inspired the entire opioid industry to follow suit. Purdue Pharma promoted its opioid OxyContin as non-addictive and as appropriate not just for severe pain on a short-term basis, but for moderate to severe pain on a long-term basis. Indeed, Purdue Pharma went so far as to fault physicians for underprescribing opioids to people in pain. Prior to 1995, opioids were thought to be too addictive for prescription to those with moderate pain. They were prescribed for short-term use in instances of severe pain, such as that suffered by certain cancer patients. Purdue Pharma's new promotion yielded big bucks for the Sackler family, who wholly owned it. The Sacklers generated over $35 billion in sales of OxyContin, causing them to be listed by Forbes as one of America's richest families in 2015, having a net worth of $14 billion. Although in 1999, only 4,030 people died from opioid abuse, by 2017, that figure jumped to 47,600, with 1.7 million Americans addicted to opioids. In 1997, 670,000 prescriptions were written for OxyContin. In 2002, 6.2 million prescriptions were written for the drug. There is another part of this story, seldom mentioned, but without this part, there would be no opioid crisis. It involves FDA corruption and industry capture. You see, in the mid-1990s, the FDA team medical reviewer on OxyContin was Dr. Curtis Wright. Without any proof of long-term safety for OxyContin, Dr. Wright recommended to then FDA Commissioner Dr. David A. Kessler that Purdue Pharma's relabeling request be granted, permitting long-term use of the opioid for moderate pain. Dr. Kessler agreed, turning a blind eye to the risks of addiction. A short time thereafter, Dr. Curtis Wright left the FDA and he went to work for Purdue Pharma. Embarrassed presently, former FDA Commissioner Kessler has since admitted in an interview with the Clarion Ledger, if FDA had done its job properly, it would have told Purdue and other opioid manufacturers, we're going to let you promote opioids for palliative, that is serious illness, such as cancer care, period. But of course, FDA did not do its job. Rather, as is common for the agency, it served as a patsy for a pharmaceutical company and approved new drug uses without adequate evidence of safety and against a wealth of evidence of risks of addiction. So much for the watchdog of public health. It opened the floodgates to one of the largest public health crises in American history. DEA, Protectionism and Bias. In 2008, the Drug Enforcement Administration informed one of its license holders, Novelty, Inc., that the agency intended to revoke Novelty's DEA registration. The DEA explained that Novelty posed an unacceptable risk of diversion of its pseudoephedrine cough and cold remedies to the illicit methamphetamine trade. The charge perplexed Novelty because it had taken extraordinary steps to guard against diversion. Its registered products were kept in locked cages at the factory, were kept in special locked safes within Novelty trucks that transported them, were removed from the trucks only upon a driver's notice to the company via handheld smart devices that kept tabs on the items from company to delivery, and were held at convenience stores in special Novelty cases that were locked and under the supervision of trained sales attendants. While story after story of thefts from pharmacies filled the newspapers concerning methamphetamine diversion, DEA remains sheepish in its willingness to prosecute pharmacies and instead focused its almost exclusive attention on what it called non-traditional markets, and in particular, its licensees that serviced convenience stores. Unbeknownst to Novelty, before the start of the case, I represented Novelty, DEA Administrator Michelle Leonhardt had met with lobbyists for the pharmaceutical industry, and after the meeting, directed DEA to pursue so-called non-traditional markets, to the apparent exclusion of pharmacy distributors of pseudoephedrine-containing cough and cold remedies from the principal pharmaceutical companies. The obvious result was to create a market advantage for pharmacies and for those drug companies at the expense of convenience stores and their providers, and to the disadvantage of consumers in costs and access. In the DEA hearing on revocation of Novelty's registration, the case came on the heels of over 24 others in which every provider had its registration revoked regardless of proof. In our case, we succeeded in supplying evidence not only of the absence of any actual diversion, but also of the absence of any reasonable risk of diversion. We established through the expert testimony of Dr. Joanna Shepard-Bailey, now Dr. Joanna Shepard-Bailey, was Joanna Shepard then, economist and law professor at Emory University, that the DEA's expert was incompetent. For its part, the DEA offered no evidence of actual diversion, but the ALJ permitted the DEA to speculate that diversion was possible and to fill the record with irrelevant reports of diversion in convenience stores not served by Novelty. Upon a robust record establishing no evidence of diversion by Novelty and ample Novelty measures to guard against diversion, the DEA administrative law judge took an extraordinary step of departing from that long line of cases recommending revocation and instead recommended that the DEA administrator not revoke Novelty's registration and work with the company instead. The ALJ wrote, "Based on this record, I conclude that this is a case where teamwork between the DEA and this major distributor would further facilitate the public interest. Therefore, I recommend that the Deputy Administrator not revoke this registrant's registration. Rather, I recommend the Deputy Administrator use her discretion to levy compliance requirements upon the respondent." But alas, DEA Administrator Leonhardt ignored the recommendation and the weight of the evidence and revoked novelties registration, predicated on the unremarkable proposition and truism that diversion risk, ever present in the industry, existed here also. The good news is that after the decision, negotiations resulted in a return of novelties registration. But nevertheless, the case reveals the irrational agency bias and favoritism for one set of regulatees, pharmacies, over another, suppliers to convenience stores. FTC, arbitrary rule, corruption, and censorship. In 2014, ECM Biofilms was prosecuted by FTC for alleged deceptive advertising. One word used by the company in its advertising was said to be deceptive: biodegradable. The FTC announced in its green guidance document, not a formal rule, that biodegradable, the term, could only be used if a product caused a plastic to experience a complete breakdown into elements in nature within 1 year of customary disposal. Leading experts on biodegradation laughed at this definition, were perplexed by it. They use gas evolution tests to determine if a plastic is intrinsically biodegradable. They explain that ambient moisture and temperature affect the rate of biodegradation, but not whether a plastic is intrinsically biodegradable. Moreover, biodegradation does not result in a breakdown of a plastic into elements. It breaks it down into compounds. So it's literally impossible to break a plastic down into elements. The very definition that the expert agency chose was inexpert and idiotic. Decades ago, ECM's founder invented a proprietary food source for biota that could be heat melded into plastics with the same uniform distribution as a colorant. That additive was the subject of dozens of gas evolution tests, not by ECM, but by large prospective purchasers of the additive. The gas evolution tests repeatedly confirmed that the additive hastened biodegradation, causing conventional plastics ordinarily impervious to biodegradation, taking tens of thousands of years to disappear from the environment, to biodegrade within several years upon burial in the ground or in a landfill. If biota were present, the additive became a food source, and biota consumed not only the food source, but also the plastic to which it was melded. During a deposition of ECM's principal by the FTC's lead attorney, Katherine Johnson, she sprung upon him new evidence which she did not provide to ECM or to me in advance, despite the fact that she had it in her possession. That evidence purported to show a published study of a gas evolution test of ECM's additive that failed to show biodegradation. The administrative law judge sanctioned her for wrongful withholding of the evidence, but could only sanction her by name only, not by any actual punishment. That power is not given to the administrative law judge. As proof ultimately established, the FTC itself had caused the test to be undertaken by a scientist, but failed to have custody of the test article properly controlled, and had it manufactured by a competitor of ECM. So it was impossible to know if the test plastic was infused with an active additive or was properly heat melded. Then FTC caused the study to be published. Efforts to subpoena third-party witnesses were then blocked by the FTC itself without informing counsel for ECM. FTC simply wrote to each party receiving one of my firm's subpoenas that it did not need to respond to the subpoenas. At trial, the sponsoring scientific witness for the failed gas evolution test testified under cross-examination to an absence of controls, rendering the evidence useless to the government. In the end, while there were several well-designed gas evolution tests showing biodegradation, there were none from the government disproving biodegradation. At the time of another deposition, the FTC engaged in additional misconduct. At a break in my deposition of Shane Frederick, PhD, the FTC's consumer perception expert, FTC attorney Jonathan Cohen asked to speak with me privately. He told me that if ever I expected to settle the case with the FTC, I would need to file a pleading recanting our earlier motion for sanctions against FTC attorney Johnson and seeking withdrawal of the order against her. I told him I considered his request illegal and unethical and refused to do as he asked. He said that unless I changed my mind, the FTC would not entertain settlement with my client. And indeed, the FTC did not. How about that for an illegal quid pro quo? At the start of the ECM hearing, FTC's counsel repeatedly urged ECM's attorneys, I being one of them, to agree in advance not to object to any of the government's questioning. We, of course, refused to give up our client's right to object, but the boldness of the government's request to deny rights of the accused proves not only prosecutorial bias, but also no interest in the integrity of the process. Then, during my cross-examination of the FTC's lead scientific expert, Dr. Stephen McCarthy, he admitted that he had not written a critical part of his own expert report, the definition of biodegradable, but that the FTC's counsel had written it for him. He further stated that what was written by the FTC lawyer differed from what he actually believed. In the ECM case, the administrative law judge ruled in favor of ECM on the biodegradation claim, a rare event in FTC deceptive advertising cases, finding that a preponderance of the evidence favored the conclusion that ECM's product actually worked as claimed. He recommended against adverse action by the FTC on the biodegradable claim. Then on appeal, the FTC rejected the recommendations, refusing to allow use of the claim, even with disclaimers concerning the extent of biodegradation achievable in gas evolution tests of the product. But wait a minute. The Commission always rules in favor of itself. It always does. That should be no surprise then. FTC writes the rules, prosecutes the accused, and judges the outcome. As former FTC Commissioner Joshua Wright explained in 2015, in 100% of cases where the administrative law judge ruled in favor of the FTC staff, the Commission affirmed liability. And in 100% of the cases in which the administrative law judge found no liability, the Commission reversed. This is a strong sign of an unhealthy and biased institutional process, you think? On appeal to the Sixth Circuit, the panel consisting of 3 judges appointed by Democratic presidents upheld the FTC the FTC decision. Yet its decision actually ruled in a manner favorable to ECM by holding that the FTC did not bar ECM from using the word biodegradable with disclaimers, so long as the extent of biodegradation achieved in gas evolution tests was revealed to purchasers. Ironically, even before litigation commenced, ECM told the FTC it would accept a reasonable disclaimer connected with its use of the word biodegradable in advertising. After years of very expensive litigation, ECM got what it proposed in the first place. The ECM case is a textbook example of agency arbitrary rule, corrupt litigation practices, and agency censorship. TTB, protectionism and censorship. In 2016, my client, Bureaucratic Technologies, went to the TTB, Treasury and Tax Bureau, with scientific evidence that a proprietary additive it had created for its Bellion vodka had strong antioxidant effects. The evidence, using state-of-the-art testing, established that the additive, which went by the name of NTX, substantially reduced the damage caused by alcohol to DNA. Although charged exclusively by Congress to evaluate claims for alcohol products, TTB admitted that it lacked expertise sufficient to evaluate the Bellion vodka claim and farmed out the work to the FDA, an agency with no jurisdiction over alcohol. FDA then deemed all Bellion claims to lack that evidence which it requires to support drug claims under the drug claim standards, but gave no scientific justification for its specific determination against Bellion's DNA risk reduction claim. While the TTB said that it reviewed the FDA's work, it merely adopted FDA's findings without deviation and without analysis. On appeal from the agency to the U.S. District Court, that court deferred broadly to TTB under Chevron deference and refused to evaluate Bellion's science, accepting instead the TTB's determination. We've since appealed to the U.S. Court of Appeals, where the case is now pending. The Bellion case reveals TTB exercises unbridled censorship in violation of the First Amendment and will not allow the American marketplace for alcohol to include ingredients that will improve the health of people who use alcohol. The history of the federal regulatory agencies is a shameful legacy of violation of individual rights to liberty and property, unconstrained exercise of absolute power by the extra-constitutional fourth branch of government has borne fruit in the selective destruction of thousands of companies, the ruin of tens of thousands of reputations, and the loss of jobs, economic opportunities, and freedom. The administrative state, a bureaucratic oligarchy, is unjust and destructive to the people's liberties and property. The solution is to eliminate the administrative state in favor of the rule of law. In closing, I think the 11th Chief Justice of the United States Supreme Court, Charles Evans Hughes, summed up well the problem of the administrative state when it first reared its ugly head. He wrote then in 1920, "Disregarding the lessons of history, there has been a disposition to revert to the methods of tyranny in order to meet the problems of democracy. Intent on some immediate exigency, and with slight consideration of larger issues, we create autocratic power. And we should know by this time that arbitrariness is quite as likely to proceed from an unrestrained administrative officer of the Republic, reigning by the grace of an indefinite statute, as by the personal government of a despotic king." Thank you.
Jonathan, you are so efficient in your presentation that we actually have time for questions.
Great.
Would you be up for that?
I'm for that.
Anybody got questions for Jonathan? This answers the question of how did we get here? This was real history lesson here. Jeffrey Smith has a question. I'm going to find him right up front. Here we go.
Jonathan, brilliant as always. Thank you for
sir.
this amazing contextual blasting of administrative law. So I would like to know your opinion on something that's very dear to me. The Trump administration just signed an executive order in June to try and eviscerate any requirements for evaluation of GMOs in the United States and to try and bulldoze away any regulatory requirements, safety assessments around the world. The new GMOs are cheap and easy and can target anything with DNA, and once they're released into the environment, they persist for absolutely forever. So there's a property issue. You release a bacteria here, soon it'll be around the world, every single place on Earth. So now we're in a situation where this generation could replace nature with a corrupted gene pool, with a technology whose number one most common result is surprise side effects. And if we don't have a regulatory constraint or safety issues, and we wait until the courts process and realize, oh, we've just replaced nature in the last 20 years, and now there's no going back, how would you use government or regulatory agencies or the courts or anything to prevent this existential threat from taking hold?
Well, at the individual level, there is nuisance law, which has been used just recently successfully against the opioids, and it can be used against any nuisance. The problem with relying exclusively on nuisance law is that you're already affected, right? It happens after the fact in most instances. You must show that there has been a nuisance created in the first instance. So nuisance law is certainly available. In the end, when there's an executive order like this from the White House, it becomes very difficult because it's implemented through these regulatory agencies which are unaccountable to the courts, the Congress, the American people. But there could also be litigation under existing federal law germane to the fact that these substances are actually carcinogenic or otherwise present an injury. The best thing, which is unfortunate with a dysfunctional Congress, is to get legislation passed which would reverse course on this The best approach may well be through the White House, ironically, because as was the case with the right to try legislation, which years and years ago for Congressman Ron Paul, I drafted what is the right to try legislation. And he introduced that again and again and again, with it never moving out of committee. And the ear of President Trump was grasped by patients who were in dire need of unapproved drugs because FDA-approved drugs were killing them. And he was quite sympathetic with that. And then, unbeknownst to all of us who had been trying for years to get legislation passed, he announced at his State of the Union, to the shock of the pharmaceutical industry and to Congress that was protecting them, that he was going to insist upon passage of the right to try bill, and it was passed and he signed it into law. I think this is a case where if a large number of people were to raise this issue and were to lobby the president on it, he might well do something. I wouldn't rule that out. The one thing about President Trump that has been predictable is that he is unpredictable. And that can serve to your advantage in this situation. But it's a tragedy because it shows that the industry has the law by a stranglehold and is succeeding in getting law. And this started, you know, when I largely wrote the bill in Maine and wherever else the Maine bill was also introduced for labeling of GMOs. You know, it was Mike Pompeo, who's now the Secretary of State, who introduced federal legislation to preempt the laws that I helped get passed in service of your same agenda. We're on the same page. And so they have tremendous lobbying power, and we have to expose it and constantly bring it to attention. You've done wonders in that regard. Yeah.
Dr. Peter Glid.
Jonathan, have you seen any trends lately coming out of the FTC regarding vitamin speak, right? You know,
Yeah.
label claims, and are they litigating against nutritional supplement companies with any ferocity? Has that kind of calmed down? Do you have any predictions about what the future might hold?
There's a constant career bureaucracy within the FTC that is an advocate against supplements in the sense that they regard dietary supplementation as worthless, and so they think that any claim of effectiveness is deceptive. There used to be a memorandum of understanding between FDA and FTC whereby FTC would not, if FDA took an action, FTC wouldn't act on the same matter. So if FDA acted against a supplement product, FTC wouldn't chime in, and also FTC wouldn't unilaterally start a deceptive advertising prosecution if FDA was of the mind that this is truthful. So for example, if you approved a claim, I petition the FDA and they approve a claim, FTC would defer to FDA. That was torn up during the Obama administration so that FTC will prosecute you even if you have an approved claim from the FDA on deceptive advertising related to the claim the FDA said was fine. And they are very much interested in prosecuting parties for homeopathic product claims. This was started by plaintiffs' attorneys in California principally, where they would go after homeopathics and say they're not tested and they're deceptive because they suggest these things and they aren't proven in Western science to establish those effects. And they would file class action suits against these makers. And that became popular in California legislative circles, and then it became popular with the FTC. They liked that idea. So we're likely to see more prosecution by FTC against homeopathics.
Would this be accelerated with the, we just covered this on Thursday's edition of the show with you and me, the elimination of the CPG 400.400?
Yes.
Relate that to everybody, if you will.
Yeah, so it used to be that there was essentially a non-enforcement. The government would not take enforcement against a homeopathic manufacturer if they made their product in accordance with the homeopathic pharmacopoeia of the United States, and also made claims that were allowed in the treatises for homeopathy, the traditional treatises, Clark and so on. They would not take any action. That would be sufficient, and they wouldn't act, even though they have always said, even though I would argue they don't have this power under the statute, they have always said that we can prosecute, we can proceed against them, but we're just taking what they call enforcement discretion. We're choosing not to act. Well, just last week they revoked that compliance policy guide. Again, interesting. Notice they use a compliance policy guide. This is rife throughout the federal government. They use a compliance policy as a rule and don't go through the rulemaking process under the Administrative Procedure Act. It's another massive assumption of power, heavily steamrolled in the Obama years and the end of the George W. Bush years, where they would just use these guides and avoid any comment, avoid any participation at all, and get exactly what they want, and breathe down the back of the industry. In the FCC context, former FCC Chairman Newton Minow called it regulation by raised eyebrow, where regulators would simply suggest that something is bad, and then the whole market would flee from it, even though there's no adoption of a law through even the regulatory process.
Jonathan, where are you going to be this weekend? You going to be here to talk to folks that have questions outside of the forum here?
Yep. And I'll be on the NORI panel at 2.
Right, Health Freedom Panel with George Norrie. Hope y'all plan to attend that. I got time for, I think, 2 minutes. One more question. Diane, do you have anything? No? It's okay.
Yeah.
Hold on, let me get you on this so we can hear you.
In the 60s, I understand, children just got like 6 shots, and now children are getting 72, I think. Nobody knows how this is going to affect children later on.
Yeah, we have a gross deprivation of individual liberty taking place in California, other states too, where they're trying to revoke the exemptions from vaccination. This is about as intrusive as you can possibly imagine. The number of vaccinations have gone way up. It's an industry that is profitable by force of the government, the state governments. You have
no
people
liability.
like Pan. You have not Peter Pan. What's his name?
Richard Pan.
Richard
I call him
Pan.
Dickie.
You have these authoritarians who think that they aren't satisfied with just taking care of their own families. They want to take care of yours too, and they want you to, not only kids, but as Robert has pointed out on the show, he's pointed out that Pan's trying to get mandatory vaccination for adults too.
And they're going to do it through, we've talked about this on the program, through ID requirements, expansive ID requirements because of Real ID.
So here you have a real authoritarian who wants everybody. And what's amazing about this is, you'll have let's say we have an outbreak, whatever that is. We have an outbreak. So we have, let's say, one school district in California, and there's suddenly all these measles cases. Well, of course, there are many ways of addressing that, not least of which is to have homeschooling. I mean, you say, on the myth that everyone who's vaccinated is going to be okay, because that we found that people who are vaccinated do get the measles even when they're vaccinated to some extent.
Yes.
Stop.
Yeah, we got to stop here, folks.
Okay.
There's going to be a lot more this weekend. Jonathan can be heard on the Robert Scott Bell Show every Thursday. Sacred Fire of Liberty. Thank you. Thank you all. Glad you're here at the Health Freedom Expo. We'll see you around.